If the defense makes the first settlement offer or settlement overture and to start negotiations, does that mean you are likely to get a better outcome than if your attorney were to started settlement negotiations? Would you like to know what this is all about? Come join me for a walk through the neighborhood as I share with you the answers to those questions. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. You brought a lawsuit claiming that your doctor and hospital staff were careless, causing you significant harm and injury. And now, for the past year, your attorney has told you that the defense has no interest whatsoever in trying to settle your case. They believe they did absolutely nothing wrong, and they will see you at trial. So now you have resigned yourself to the fact that you are ultimately going to go to trial, and now, during the course of discovery, you are waiting every step of the way, hoping and praying that that changes. You're hoping that settlement discussions get started and that you don't have to go all the way to trial and have a jury, 6 members of the community, render a decision about whether you are slightly more likely right than wrong than what you are claiming is true. Now, after you have given your pretrial deposition, your attorney calls to tell you that the defense did something remarkable. They have changed their position. The defense has reached out to him, and now they have said that they would like to start negotiating. They feel that the case should be settled, and they would like to start negotiating. What does that mean for you in your case? Is that a good sign? Or does that mean that it's a bad sign because now, halfway into your case, they want to start negotiating? And you begin to think, wait a second. If they want to go ahead and start negotiating and the case is not done with discovery, does that mean they're looking to get out cheap, meaning that they want to settle this case now so they can save on costs and expenses and get a lower value or try and give you a lower value to settle your case? The answer may be yes to all of those things. Why? The defense may have come to the conclusion that this is a losing case for them, or that the risk of taking your case all the way to trial is extremely risky, and that there is a very good likelihood that they will lose at trial. If they come back and want to go ahead and start settlement discussions, it means that they have analyzed this case. They are now determining or trying to decide what the value of your injuries are. And now, as part of that analysis, they have to evaluate what the likelihood of what a jury will do at trial. Will they give you a substantial amount of money to compensate you for the harms and the injuries that you suffered? Or will they take the risk of going to trial knowing full well that your injuries are not that serious and that they are within a parameter that they are willing to live with no matter what the jury comes back with? That's a risk analysis and a risk assessment that the defense does in every single one of these cases. There are some instances where they do that risk analysis sooner rather than later, meaning that they get around to recognizing that, hey, they have no defense here. No matter what they do, they cannot defend what actually happened. And they recognize that a jury will not be sympathetic to them, to their clients, and they feel that a jury, if they come back in your favor, showing that the doctor and hospital staff were careless, they may take it out on them by giving you a very substantial amount of money to compensate you for all of your injuries. In an effort to try and limit their losses, they may decide, you know what? It's a better business strategy, a better tactical strategy, if we try and start settlement negotiations now. So let's go back to the question I raised at the beginning of this video. If the defense, in the middle of your case, reaches out to your attorney and says, hey, listen, we've looked at the case, we think it's a case that should be settled. That's code for basically saying, we realize we have a problem, a liability problem. And now we are concerned that if we take this case all the way to trial, that a jury is not going to rule in our favor, and instead will likely rule in your favor. That's really what that means. Okay, so given that statement, go back to the question I raised at the beginning of this video. Does it mean now that the defense is much more likely to offer you more money than what your injuries are really worth? And in my opinion, the answer most often is no. Now, why is that? The defense knows that the longer your case goes on without being resolved, the more expenses that you and your attorney will incur to prosecute this case. Now, the same exact thing is true for the defense as well. The longer it goes on, the more expenses and legal costs and expert fees that are going to be associated with defending the case. So they know that, and they are trying to say, listen, if we go ahead and settle this case now based upon the offer that we give you, we are now willing to settle this case, but it has to be at a significant discount. If you are okay with that, if you and your attorney are okay with that, fine, the case can be resolved. You reach an agreement as to the value that they're willing to offer compared to what you think the case is worth. And you may turn around and say, you know what? It's not worth it to me. I'd rather go the distance. I'd rather go further. And you might also be thinking, wait a second, if this is their first real substantial offer, and now we have not yet gotten close to trial, doesn't that mean that if you hold out for more, that they will likely offer more money? The short answer is maybe. And that's a big unknown. Your attorney is going to have a better understanding from talking with the defense attorneys about whether or not that may happen. Your attorney may turn around to the defense and say, listen, that's not sufficient. That's not going to happen. Do you have any wiggle room? Do you have any leeway? Is there more money available that we can try and discuss? And if they come back and say, you know what, that's a possibility, I'd have to go back and speak to our principals. In that instance, your attorney may believe or get the impression that there may be more money available. However, there are instances where the defense comes back and say, listen, this is our number. We are not going to increase our offer. It's either take it or leave it. If you don't want it, fine, then we're going to keep going forward with the litigation, and then we will go all the way to trial. Let a jury decide whether you are slightly more likely right than wrong than what you are claiming is true, and if so, how much your injuries are worth. So going back to the question I raised at the beginning of this video, the fact that the defense has now started settlement negotiations, does that mean that you are much more likely to achieve a successful outcome? The answer is maybe. But keep in mind, and don't get frustrated if you hear your attorney tell you that they've offered an amount of money that is clearly different than what your perceived value of your injuries are. In other words, the defense is willing to negotiate and settle your case now, early on, but they're not willing to offer full value for your case. They're willing to discount it. And if that's okay with you and you want to live with that, that's perfectly okay. However, if it's not, now you keep moving forward, and there may be additional settlement discussions in the future, but you have no idea what those will be or whether or not that will ultimately resolve your case. So why do I share this quick information with you? I share it with you just to open your eyes and to help you understand how these types of cases work in the state of New York. And I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.